For the first time in South Africa, charges of crimes against humanity for which jurisdiction falls under the International Criminal Court will be pursued in a domestic murder case. Charges have been brought against an apartheid police officer and former soldier accused of attacking 4 activists from the Congress of South African Students in 1982. The Johannesburg High Court today dismissed their objection to the charges, paving a way for similar prosecutions in other apartheid-regime crimes. Newzroom Afrika's Karinda Jagmohan has the details.
Apartheid officer Christian Rorich and defector to the apartheid regime Tlomedi Mfalapitsa are accused of the murder and attempted murder of 4 student activists in the West Rand in 1982. They unsuccessfully submitted that the crimes against humanity charges against them would not stand in the Johannesburg court.
Based on South Africa's international obligations, there can be no time bar for the prosecution of crimes against humanity. The seriousness of crimes against humanity must be prosecuted irrespective of when they occurred. Therefore, there is no period within which such charges must be brought. A delay in prosecution is not a defence in law to these crimes.
The ruling marks a significant turn in the prosecution of apartheid crimes, with more than 150 similar cases before courts across the country.
This is so big because it widens jurisdiction. It means that we don't just have to rely on domestic courts. We can widen and go internationally if that would be the remedy or the solution. Because as you have noted over the years in South Africa, is that there's been a delay. We have not made significant progress in dealing with apartheid charges domestically. And so the hope, not just as the Foundation for Human Rights and our pro bono partners and lawyers, but as the families particularly, is that now we will be able to deal with these crimes internationally and perhaps get relief in other international forums and widen the search for truth and justice.
While it's also a triumph for the National Prosecuting Authority, prosecutors must still deal with ongoing delays in the case as the defense proceeds with an application for the judge's recusal.
It has been years that families are longing for closure and to see justice finally happening in these cases. And therefore, we cannot be seen as the NPA promoting such delays. Hence, we need to invoke Section 342A where, in circumstances where there is a need to do so.
This will allow the court to investigate delays in the case as families await justice.
It's been 43 years now, and every time they seem to be coming up with a delay in tactic. At least we are seeing the light that there's movement, not just for us, because basically a judgment like that sets a precedence for other cases as well.
The Cosas 4 murder case resumes on Wednesday. For Newzroom Afrika on Channel 405, I'm Karinda Jagmohan in Johannesburg.